Recent research suggests that as much as 1/3 of the US workforce is bound by a non-disclosure agreement. Despite criticism that they suppress free speech and allow bad conduct to go unpunished, non-disclosure agreements, commonly known as NDAs, don't appear to be going anywhere. We're eForms, the world's largest online database of fillable legal forms, and in this video we'll cover what NDAs are, what kind of terms they contain, and how they differ from related kinds of contracts. If you're a business owner with information to protect or an employee thinking about taking a new job, it's never been more important than to understand non-disclosure agreements. For a non-disclosure agreement that meets essential requirements and can be customized to fit your situation, click the link that appears at the end of this video. First, let's establish what a non-disclosure agreement is. An NDA is a contract in which one or both parties promise not to disclose certain information. NDAs are used in many different kinds of businesses, but there are two main types. A unilateral NDA just binds one party to the agreement. A mutual NDA binds both parties. Non-disclosure agreements can be very useful in industries like tech, in which employees have to be exposed to sensitive information in order to be able to do their jobs. Employers will often ask new employees to sign an agreement prohibiting them from sharing sensitive information learned on the job with a competitor or to the public at large. The internet has made these types of agreements extremely important because once the information is out there, it's very difficult to remove it or prevent others from exploiting it. A less common but more notorious type of NDA involves those created as part of a legal settlement, in which one party agrees not to disclose information that is injurious to the other in reward for payment. This type of NDA remains mostly legal, but they are facing increasing skepticism. So, what kind of terms do non-disclosure agreements contain? As mentioned previously, NDAs are commonly included in employment contracts and may form their own section or be included as an attachment. They usually include covered information. Most states have their own laws defining trade secrets, which have their own form of legal protection. NDAs can be broader, including things like all confidential information learned as a result of employment. Effective dates. This involves establishing when the NDA is effective. Often they will start immediately and last until some amount of time after the employment ends. Consequences for violation. NDAs often contain a liquidated damages provision, which is a contract clause that determines a set amount of money owed if a party breaches their obligation. Liquidated damages can help because they make the consequences of disclosing information clear to both parties. They can be especially useful in cases of information related to new or emerging technology, because it can also be very difficult to calculate how much a party is harmed by the release of such information. Along with NDAs, you may have heard of a non-compete agreement. How are NDAs different? Non-compete agreements are contractual provisions that prevent an employee or business owner from competing with another business, usually the one that formerly employed the worker or who brought a business from the former owner. Many jurisdictions consider both NDAs and non-compete agreements to be restrictive covenants that are only enforceable in certain cases. The answer will ultimately depend on where you are, but because non-compete agreements cover many different types of conduct and can be more limiting on an employee's future job prospects, a court may be more likely to enforce an NDA. NDAs can be complicated, but having an agreement that works is essential for both employers and employees. Be sure to watch our second NDA video in which we break down things that can invalidate an NDA, and subscribe for other videos about other relevant business law topics.